Welcome back to Chapter 2, The Legal Environment of Forensic Accounting. Learning Objective 7, identify the requisite elements for establishing attorney-client privilege. So the legal principle that protects communications with protected relationships is attorney-client privilege. Privileged communication is a legal principle that protects communications taking place within a protected relationship. Commonly recognized protected relationships include attorney-client, husband-wife, doctor-patient, and clergyman. So the privilege is a legal right of the source, for example, the client or the patient, rather than the lawyer or the doctor. So the underlying theory of privileged communication that's articulated in the U.S. Supreme Court in Upjohn Company versus United States, 1981, is that certain instances, society is best served by the suppression, which is protection from disclosure of information. So the suppression of information is inconsistent with the general duty to disclose and thus closely guarded by the courts. So in the discovery phase of civil litigation, each party is obligated to disclose to the opposing party all relevant and non-privileged evidence it proposes to use in the trial, whether favorable or not. Attorney-client privilege is the oldest of the protected privileges in law, and it's defined as the client's right to refuse to disclose and to prevent any other person from disclosing confidential communications between the client and the attorney. So the requisite elements for establish this privilege include a communication that relates to the rendering of legal service, is made in confidence, and is made to a person in the client reasonably believed was an attorney. So the attorney-client privilege is intended to encourage individuals involved in legal disputes to be candid with their attorneys, thus enabling attorneys to give sound legal advice. Once the attorney-client privilege has been established, it may be extended to non-attorneys, such as subordinates and consulting experts who assist attorneys in rendering legal advice or services. So the work product doctrine, 1947, provides protections from discovery of documents, interviews, statements, and other items prepared by an attorney in anticipation of trial. So the work product doctrine allows lawyers to prepare for litigation without risk that their work will be revealed to court adversaries. So consistent with the rules governing attorney-client privilege, the work product doctrine can be extended to items prepared by non-attorneys who assist in rendering legal services. So extending the attorney-client privilege and the work product doctrine, right? So communications between attorneys and consulting experts are generally protected under the attorney-client privilege, or it could be protected under the work product doctrine. Until recently, there was no such protection was afforded to communications with a testifying experts. So that changed in December of 2010 which was amended to allow the extension of work product protections to most attorney expert communications and to all draft expert reports. So this was a highly practiced change which served to reduce the cost of litigation and make the process more efficient. Working with attorneys. So in addition to the rules and principles that we've discussed, another key element of the legal framework is working with attorneys. An effective forensic accountant must have an open and honest working relationship with engaging counsel. There are, of course, many keys to maintaining this relationship. One top 5 include the following: communication, respect, responsiveness, responsibility, and ethical obligations. Communication. There must be a clear understanding of what the forensic accountant has been engaged to do and the timeline in which the work is expected to be completed, the nature and the venue of the case, if it's going to be federal, state, civil, or criminal, and the payment of fees. So this understanding should be clearly articulated in an engagement letter executed by both parties. Respect. There must be mutual respect between the parties in their respective roles. It is understood that lawyers advocate for their client with the intent of winning. In contrast, a testifying expert advocates for his or her opinion. So the forensic accountant, when they're serving as an expert witness, must remain neutral and objective to not allow influences of engaging counsel. Responsiveness. The forensic accountant must be responsive throughout the engagement, from the gathering and analysis of data to the timely development and presentation of the final report. The attorney must also be responsive in providing the expert with any requested information and promptly advising of schedule changes. Responsibility. The forensic accountant has a responsibility to the engaging attorney to exercise competence and due professional care in the development and presentation of his or her opinions. The forensic accountant has a responsibility to the court to develop and present opinions honestly and objectively. Ethical obligations. In almost every case, there's some gray area will arise that has to be resolved in a fair and ethical manner. So to avoid a claim of adversarial bias, a common practice is to resolve such issues in favor of the opposing party. But there is no clear answer. These concerns must be openly discussed with engaging counsel.